Move on to question 5. Where can a court annul the domestic arbitral award under the LCA 2010? Um, case case in which the court can annul a domestic arbitral award under Clause 2, Article 68 of the LCA include the first is that the arbitration agreement is not legal because the parties do not have an agreement or the agreement is invalid. In principle, the parties may only resolve dispute by arbitration if there is an agreement. However, if the agreement between the party does not specify which specific commercial arbitration institute will settle the dispute, the arbitration agreement will be invalid. Specifically in Clause 4, Article 10 of the 2003 Ordinance of Commercial Arbitration, an arbitration agreement is invalid when the arbitration agreement does not stipulate or does not clearly stipulate the subject of the dispute. The arbitration organization has the competence to settle the dispute, but then the parties do not have an additional agreement. Um, However, the LCA 2010 has some major changes related to unclear arbitration agreements. Regarding the case in which arbitration agreement is invalid, it is clearly stipulated in Article 18 of the LCA, including the following cases: dispute arising in area not under the jurisdiction of the arbitrator. The person establishing the arbitration agreement does not have the authority as prescribed by law, and the person established the arbitration agreement does not have civil act capacity as presented by the Civil Code, and the form of the arbitration agreement is inconsistent with the provisions of Article 16 of LCA. Um, the second is that the composition of the arbitral tribunal and the proceedings are not in accordance with the agreement of the parties in contrary to the provisions of the LCA. For example, according to provisions of Clause 2, Article 39 of LCA 2010, the compositions of the arbitral tribunal may consist of one or more arbitrator, as agreed by the parties. In case the parties do not have an agreement of the number of arbitrators, the arbitral tribunal shall consist of three arbitrators. The third is that the dispute does not fall under the jurisdiction or the award has contents that are not under the jurisdiction of the arbitral tribunal. Examples of disputes that do not fall under the jurisdiction or judgment with contents that do not fall under the jurisdiction can be mentioned as dispute that do not arise from commercial activities. Neither party has commercial activities. Such disputes are regulated to be settled by the court, according to Article 2 of the LCA. The fourth is that the evidence provided by the party is fake and the arbitrator received money, property, or material benefits from a party affecting the objectivity and fairness of the award. And the fifth is that the arbitral award is contrary to the basic principle of Vietnamese law. Move on to question 6. Compari Comparison of the enforcement of arbitral awards in Vietnam with EU or US. And in this question, we choose to compare with the US. Mm, for a legal basis, Vietnam, based on the LCA 2010 and then New York Convention or um, any international convention, and United States depends on the U.S. Federal Arbitration Act and New York Convention for recognition and enforcement of domestic arbitral awards. In Vietnam, the arbitral award takes effect from the date of insur ins issuance. Unless it is annulled or refused to be enforced, it is enforced in accordance with the law on civil judgment enforcement by civil judgment enforcement agencies without going to the court's approval or permission procedures. In United States, the enforcer must apply for recognition and enforcement of the arbitral award at a competent court for recognition and enforcement. This is mentioned in the Section 9, Chapter 1 of the FAA. Next is the difference in annulment of arbitral awards. In Vietnam, the court only considered the procedural ruling, not the content. But in the United States, the court may modify or change the content of the judgment or cancel the judgment based on the grounds in the FAA. In enforcement in Vietnam, the court does not enforce the enforcement, but it is carried out by the Civil Judgment Enforcement Agency. But in the United States, the court directly orders enforcement and takes emergency measures. And last, in settlement of the arbitration jurisdiction, both Vietnam and United States, in case the parties do not have an agreement to select an arbitrator or respondent fails to select an arbitrator within a certain period of time, the court shall appoint an arbitrator based on the request of a party. And move on to the last question. An analysis of the case this case and did the court cancel recognition the judgment, the reason and lesson learned. So summary um to summary the case, this case include the Hồng Loan Real Estate Commercial Construction Joint Stock Company and was established in 2005, including five founding shareholders: Miss Nguyễn Thị Thanh Nhàn, Miss Lê Hồng Loan, Mr. Lê Văn Thanh, Mr. Nguyễn Vinh Quang, and Mr. Lê Thanh Minh. When issuing the eighth enterprise registration certificate of the joint stock company on 2010, only Miss Hồng Loan, Văn Thanh, and Vinh Quang were named, and Miss Nguyễn Thị Thanh Nhàn was not named in the list of founding shareholders. Therefore, on 2011, Miss Nhan filed a lawsuit at Cần Thơ Commercial Arbitration Center to request to pay the contributed capital of this amount of money, and disagreeing with this ruling, the defendants filed a petition to the People's Court of Cần Thơ City to cancel this judgment of the commercial center. So, move on to case analysis. Firstly, the arbitrator's agreement is invalid according to the provisions of Point A, Clause 68 of the LCA. In the petition, Ms. Nhan said that because the charter of Hồng Loan Real Estate has the signatures of five founding shareholders, the dispute resolution is stipulated by arbitration of the court. However, in Section 8 of the charter, where shareholders have the right to repurchase shares, it is stipulated that the company must repurchase shares at the request of shareholders in Clause 1 above at the market price or the price prescribed in accordance with the principle approved by the board of directors within 90 days from the date the receipt of the request, blah, blah, blah. Moreover, in the Section 26 of the Charter stipulate that the principle of dispute settlement. In case the parties cannot reach an agreement on internal settlement with each other, the matter will be handled by competent authority of law or the court. Thus, according to the agreement in Section 8, it is not possible to determine which arbitration council or the arbitration center of Vietnam will have the jurisdiction to settle dispute. And according to agreement in Section 26 on the principal dispute resolution, it is actually a request for the court to settle without an arbitration agreement. Therefore, arbitration agreement is invalid according to provision of point A, clause 2, article 68. And, and secondly, the application of the LCA by Cần Thơ Commercial Arbitration Center is contrary to the provision of point B, clause 2, article 68 and clause 3, article 81. And thirdly, the Cần Thơ Commercial Arbitration Center forced Hồng Loan Real Estate to hold a general meeting of shareholders in excess of the litigants' lawsuit requirement. According to point C, clause 2, article 68, the above arbitral award has contents that are not under the jurisdiction of arbitral tribunal, so such content is annulled. For experience drawn, for businesses, we have to để ý when drafting contracts. It is necessary to have a clear agreement on prioritizing the dispute settlement agency as an arbitrator, specifying the place of dispute settlement and the scope of dispute settlement by arbitration, and for commercial arbitration agency and organization. We need to clearly define the validity of the arbitration agreement and only settle the content of the case at the request of the parties, and clearly determine the time when the parties agree to choose an arbitrator to determine the applicable law. And for the role of the court, the arbitral award is final but can still be annulled by the court at the request of the party with the grounds in clause 2 article 68 to limit arbitrationist ensuring fairness and consistency in the adjudication system. Move on to part B. Thanh Anh will represent you part B.
Bà muốn share hay là tôi share?
Ai cũng được.
Okay. Okay, so now I will represent you part B, practical exercises. The first exercise is to draw a diagram of the arbitral procedure under the LCA 2010. And as you can see from the screen, there are six steps in the procedure, starting with signing arbitration agreement. At this stage, the arbitration agreement must comply with Article 16 of the LCA regarding its form, and the parties are required to establish a written document expressing their mutual consent to resolve disputes arising or potentially arising through arbitration. And these such agreement may take the form of a clause within a principal contract, a separate document exchanges through email or fax, or a reference to another document containing an arbitration clause. And the second step is the constitution of the arbitral tribunal. So firstly, the tribunal may consist of one or more arbitrators depending on the agreement of the disputing parties. And secondly, the tribunal may be constituted in two principal ways, either under the auspices of an arbitral institution or as an ad hoc arbitral tribunal established by the parties themselves. And the procedure for constituting an arbitral tribunal at an arbitral institution is prescribed in Article 40 of the FCA. And the third step is the presentation of claims or defenses, and such presentation begins at the outset with the claimant's statement or claim and the respondent's statement of defense or counterclaim. And during arbitral proceeding, the party may raise additional requests such as motion to postpone a hearing or applications to annul an arbitral award. And according to Article 9 of the LCA, the parties are free to negotiate and agree on the settlement of the dispute or may request the arbitral tribunal to conduct conciliation, to facilitate such agreement. And the next step is step number 4, the meeting of the arbitral. Arbitral hearings are the stage in which the tribunal deliberates, examine evidence, and consider the parties' argument. So they conduct hearing, reviews evidence, and may proceed in a party's absence, following article from 54 to 58. And moving on to step 5, arbitral award. The arbitral award constitute the final and binding decision of the tribunal, resolving all substantive issue in dispute and terminating the arbitral proceeding and being enforceable in accordance with the law on civil judgment enforcement. And you can see Article 16 to 60 to 61 for this. And the last step is the enforcement and recognition. The award is enforceable domestically and internationally under applicable laws from in Article 62 and 65. So these are the steps, and we come to exercise 2. Applying Article 19 of the LCA, thus the arbitral tribunal have jurisdiction. And the case scenario is that Company A claims the service contract is invalid due to lack of authority in signing. Company B requests dispute resolution at VIAC, which is the Vietnamese International Arbitration. Next, please. Okay, so according to the separability doctrine, the arbitration agreement remains binding even if the main contract is invalid. And Article 19 of LCA, it also ensures that the arbitration agreement continues to exist independently, regardless of the invalidity of the contract. So the VIAC retains jurisdiction to resolve the dispute as the arbitration clause is enforceable regardless of the contract's validity. We presented you the separability doctrine before. And we come to the next exercise. An arbitral award rendered in Singapore orders a Vietnamese company to pay 2 million United States dollars. The first is the procedure for recognition and enforcement in Vietnam under the New York Convention. And the second, okay, to solve the first question first. So what is the procedure? According to Article 4 of the New York Convention, the first step the Singapore arbitration must do is to submit an application that includes the original word duly authenticated on a duly certified copy thereof. The original agreement referred to in Article 2 or a duly certified copy of such agreement. And moving on to the next step, if the aforementioned award or agreement is not made in the official language of Vietnam, the Singapore arbitration party must provide a translation of this document into Vietnamese, and such translation has to be certified. And Then in step 3, Vietnam shall recognize and enforce the award, and the recognition and enforcement of the award may be refused pursuant to Article 5 of this convention. The second question is we need to state the grounds that the Vietnamese company may invoke to refuse the recognition according to Article 5 of the New York Convention and Article 459 of the Civil Procedure Code. So our argument is that the parties to the arbitration agreement lacked the capacity to conclude such an agreement under the law applicable to each party, and the arbitration agreement is invalid under the law chosen by the parties to govern the agreement or under the law of Singapore where the award was rendered. And the next ground is that not duly and timely notified of the appointment of the arbitrator or of the arbitral proceedings, or was otherwise unable to exercise its procedural rights for justifiable reason. And the arbitral award was rendered on a dispute not contemplated by or not falling within the scope of the arbitration agreement, or it contains decisions on matter beyond the scope of the arbitration agreement. Next, the composition. The fifth reason is that the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties, or was not in accordance with the law of Singapore, the country that rendered the award. And sixthly, the arbitral award has not yet been binding on the party. And finally, the arbitral award rendered by Singapore Arbitral Tribunal has been set aside or suspended by a competent authority of Singapore, the country where the award was rendered, or of the country whose law was applied according to Article 5 of the New York Convention and Article 459 of the CPC. And the Vietnamese court may issue a decision refusing recognition when they find that the dispute is not capable of settlement by arbitration under Vietnamese law. The recognition and enforcement in Vietnam of the arbitral award rendered by the Singapore arbitral would be contrary to the fundamental principles of the law of the Socialist Republic of Vietnam, as we study in private law. And the last question of this exercise is the role of Vietnamese courts in the supervision of international arbitral awards. So, upon receiving an international arbitral award, the Vietnamese court must review and examine its legality, validity, and conformity with the provisions on recognition and enforcement under the New York Convention and Vietnamese law. And the court must ensure that the award does not violate public order or the fundamental principle of Vietnamese law. And in addition, the court also perform a supportive role for arbitral proceedings, such as appointing arbitrator when the parties fail to reach an agreement. Uh, and these are the role of Vietnamese court in such supervision. Yes. Next, please. Okay, exercise 4, we will analyze the decision number here of Cần Thơ, and we did summarize the case before, so we move to the key legal issue. Yeah, thank you. So based on this decision, the central legal issue in this case identified as follow. First, regarding arbitral jurisdiction, based on Article 8, dated in 2005, and Article 26 of the charter of this company, uh, we cannot determine which arbitration court or arbitration center in Vietnam has the authority to resolve such disputes. uh, Regarding the validity of the arbitration agreement, the party agreed that should a dispute arise, it would be submitted to the Vietnam International Arbitration Center. However, the case was instead accepted and resolved by the Cần Thơ Commercial Arbitration Center. So, regarding the validity, this decision cited and applied the law on commercial arbitration of Vietnam, which was incorrect under Clause 3 and Article 81 of the law on commercial arbitration. And such provision prescribe that the dispute must be resolved under the Commercial Arbitration Ordinance, but the Cần Thơ Commercial Arbitration Center has applied the commercial arbitration law. So, how did the court reason? The court said that the agreement in Article 8 of the Hồng Loan Company Charter dated January 28 on 2005 on cases in which shareholders have the right to request the company to buy back their share is not consistent with Mr. Nhang's request, and Article 8 of the Charter does not specify which court or arbitration center in Vietnam has the authority to resolve disputes. Article 26 of this charter requires the court to resolve dispute without an arbitration agreement. On the other hand, the parties agreed that the Vietnam International Arbitration Center (VIAC) under VCCI would handle the case. Therefore, the Cần Thơ Commercial Arbitration Center's handling of the case was not in accordance with the law, and the admission in the decision not to apply legal provisions requesting Hồng Loan Construction and Real Estate Trading Joint Stock Company to convene a general meeting of shareholders is beyond the plaintiff's requests. And based on the agreement in the charter, within the effective period of the Commercial Arbitration Ordinance, the dispute must be resolved according to the Commercial Arbitration Ordinance. Therefore, the application of the commercial arbitration law by the Cần Thơ Commercial Arbitration Center is not in accordance with the agreement of the parties. So, what can we learn from such cases? When drafting arbitration clauses, it must be established in accordance with the law, especially clause 1, Article 5 of the LCA, and it must it must be pursuant to Article 2 of the LCA. The arbitration agreement shall be settled in accordance with Article 16 of the LCA. And we must also pay attention to the voluntariness of the parties, their legal capacity, and the validity of arbitration agreement in accordance with Clause 2 and 3, Article 5 of the LCA. And we need to designate the arbitration organization to resolve the dispute, the language of the proceeding, the number of arbitrations, the applicable law, and other necessary factors to avoid the arbitration award being set aside under Article 68 or the award being declared invalid under Article 18. So we have a case in exercise 5. The situation is that the Vietnamese enterprise, which is the buyer, and the Korean supplier, which is the seller, The buyer files a complaint regarding the quality of goods, while the seller accepts that the contract contains an arbitration clause in Singapore. So now, my group will make a role play on this to help you guys understand the situation. Um, okay. Okay, so I will be the sellers, Anthony. Phương Nghi will be the buyers, Anthony, and Quân will be the arbitration panel. Can we start now?
I am the buyer.
Who?
So,
Wait. Quân will start the role play first.
Good morning, Council. We are convened today to hear argument in the matter between the Vietnamese buyer and the Korean seller. The issues before us is whether this tribunal has jurisdiction under the arbitration clause alleged to be contained in the contract. Counsel for the buyer may proceed with your submission.
thank you, Madam. Thank you, Mr. Arbitrator. The buyer submits that jurisdiction should rest with the Vietnamese court. First, the alleged arbitration agreement is invalid under Clause 4, Article 18 of the LCA. An arbitration agreement is invalid if its form does not conform with statutory requirements. The seller merely asserts that the contract incorporates an arbitration clause providing for arbitration in Singapore. However, no such clause exists in the formally executed contract. The seller's assertion is, in effect, an unclear declaration. Therefore, the arbitration agreement is invalid, or more precisely, non-existent. Second, jurisdiction of the Vietnamese court is proper under point D, Clause 1, Article 469 of the CPC. The performance of the contract, which is the delivery of goods, took place in Vietnam. The dispute may connect it directly to Vietnam, and the consequences of defective goods may affect the domestic market and the health of consumers.